What would you say if I told you that a relevant authority, which I'll explain in a minute, could apply to the court without you knowing about it to order you to do a thing even though you've not been convicted of any offence and there's no real underlying offence actually occurring, just that you've got to do what this order said, even though it was made without you being there and you had no idea about it and you didn't have the opportunity to make representations, which you would normally do in court? Welcome to the UK, because this, along with another bill that I'm going to talk about, which essentially bans various kind of humour and banter in pubs. I'll come back to that in a minute because I think that's utterly ridiculous. But these are two bills going through at the moment, which, if it weren't for me and certain other news outlets, you may not know anything about at all. So for that, I'd really implore you to subscribe to my channel because I will tell you what's going on in Parliament, how these laws apply, and how they are, in my view, going to curtail your free speech. It is absolutely staggering. It's no wonder the United States are trying to do something to get involved and say, hang on a minute, this is really not right. They can't be doing that in the UK. So let's take a look at these two bills and check out my merch while you're at it in the links below. Let's look at this first one, the Crime and Policing Bill. You may have heard of it. It's going through Parliament at the moment. It's actually bouncing along quite quickly, and now it's going to go to the Lords, and hopefully the Lords have more sense. Just briefly, if you don't understand that process, a bill is what a act of Parliament is before it becomes an act of Parliament. It starts as a bill, which is a draft bit of law. It either starts in the House of Commons or it starts in the House of Lords. It goes through various stages and then passes to the other house, whichever house it didn't start in. And if it gets through all those stages in both houses, then it comes back and it goes for royal assent and becomes an act of law. Watch the comment section go crazy because acts are law, despite what some people think in the comments. But let's go to this bill. So this is the Crime and Policing Bill, which is now, as I say, getting far along, and it's just due to go to the Lords shortly. But the Crime and Policing Bill, what am I concerned about? I'm just going to talk about one specific bit in this. There's lots of other bits as well, but this one little bit that I'm going to talk about here is under Part 1. So this will probably become like Section 1 if it becomes law. On respect orders. Now, what does a respect order mean? Well, it's quite broad. Let's start with the power, what it is, what it does, who can apply for it, what it can make you do, which will make you quite alarmed. But I'm not here to be alarmist. I'm just pointing out what the bill says. I didn't write the thing. I just don't really happen to agree with it. Opinion alert. Power to make respect orders. A court may make an order in this section known as a respect order, so long as someone is an adult. And if, only if, really, the court is satisfied on the balance of probabilities, which means all things being equal, it's just a little bit more likely than not. That's on the balance of probabilities rather than absolutely sure that this is going to happen and we need this order. It's just, well, everything's equal. There's a snippet of a reason why this is needed. Let's grant this order. That's what that means on the balance of probabilities. It's just literally more likely than not. That the respondent, you, if they're applying for this order against you, you have engaged in or threatened to engage in what they call antisocial behaviour, and the court considers it just and convenient to make the order, which again just means, well, it's better that we do than we don't in the grand scheme of things, for the purposes of preventing you from engaging in antisocial behaviour. So maybe you haven't done as yet, but a relevant authority, which I'll come back to, says, well, it's likely that you're going to do this, or it seems that you're threatening to do this thing that we call antisocial behaviour. And to prevent you from doing so, they make an order against you without you knowing about it. That's called without notice. I'll come back to that in a minute. And a respect order made for the purposes of preventing you from engaging in antisocial behaviour stop you from doing anything described in the order. Now, that's fairly broad. It can stop you from doing anything that's in the order and require you to do anything described in the order. So no conviction, no trial of issues, like you sue somebody, you win, the court orders them not to do something. If someone's done something defamatory, they order you to take it down, or if you've done something that's infringement and they order you to take it down, and so on, which is a very high bar. You know, you're not responsible for the comments of third parties, for example. They can't order you to do something on someone else's behalf or whatever. Some people think you can, you can't. But They can order you to do anything described in the order, or they can order you to not do anything in the order. They can prohibit you from doing things, and they can order you to do things in one of these orders. Now, insofar as practicable, they should avoid interference with times, if any, at which that you normally work or attend education, or any conflicts with any other court order. Of course, they wouldn't want to contradict themselves. But it must specify the period or state that it has effect until further order, which, in my general experience in court, the court does not like making permanent orders unless it's absolutely clear that there's a permanent injunction that somebody must not do a thing. Even then, they are usually with a fairly broad time frame, for the next 5 years, don't do this or something like that. And the real fun part is when we look at what antisocial behavior really means. And it defines it, well, sort of. It says antisocial behavior means conduct that has caused or is likely to cause harassment, alarm, or distress to any person. Let's break that down. I'll tell you why I've got a problem with that. I don't really have a problem with the harassment bit, because if something's proven to be harassment, first of all, it has to be a course of conduct, which means at least 2 occasions. Secondly, it's got to be conduct which is more than just offensive. It's got to be oppressive and unacceptable. So it's got to be really bad to cross that threshold, and it's got to be on 2 occasions, and then it would amount to harassment. So I don't have a problem with that. But I do have a problem with the words alarm or distress, because these are alternate things. So they say, in this bill, which is not yet law, they say antisocial behavior is anything that could cause or is likely to cause alarm or distress. As I say, I don't have too much of a problem with the harassment bit, although it is still open to interpretation somewhat, but I do have an issue with alarm and distress, because anyone can be alarmed by a comment, because that's subjective. People can be alarmed by a joke. And my view is we shouldn't be banning people for making jokes that other people find offensive. Just don't go to the comedy. They can make jokes. It's not the event that people are saying is funny. It's a twist on words. But on a reading of this, if something is likely to cause alarm or distress, that's antisocial behavior, and therefore they can apply for one of these orders, and therefore they can restrict you from doing things such as don't post on social media, delete that social media post, don't use social media, don't do this or don't do that, don't go to a certain area, whatever the order says. It's very broad, remember. And remember, there's been no civil trial of issues and a judgment, and there's been no criminal trial, no criminal conduct found against you. Just they say, the authority, which I'll come to in just a second, they say that you've either committed or you're likely to commit antisocial behavior. And that means any conduct that has caused or is likely to cause, so you haven't done it yet, you're threatening that you might do something that is likely to cause somebody to be distressed. They can apply for an order to prevent you from doing something or to order you doing something until further order. So permanently order you to do or not do a thing, even though nothing's happened yet. Now, who could apply for one of these? Because this is important. The relevant authority means a local authority, so your local council, or any of the local authorities that come under that banner. A housing provider, so if you're in social housing or whatever, the housing provider can say, oi, you're making noise that's likely to distress a person, use your imagination, stop doing that. Otherwise, you're in breach of this order. And I'll come back to the consequences in a moment. The chief of police of an area. Now, that's just the police force for that area, because everything is the chief of police that takes a step. I have on one occasion, this is really funny. It wasn't funny at the time, but it's funny that I'm telling you the story, because I had one situation where it was a family case. There were 3 police forces involved, because where they lived was between 3 different areas. And all 3 areas that had been involved because of where they were at the time, and the police were called from 3 different areas. So 3 separate forces were ordered to disclose reams of material. None of them had complied. And I was I was about to say I'm pulling my hair out, but obviously not. But I was getting frustrated that they hadn't complied. They eventually supplied DVDs, which were blank. And I'm telling you, the judge was not pleased with that. And the judge then in that case, because everything is literally, ordering the chief of police to do a thing, but it's just the force that's doing that. It's order the chief of police to provide this disclosure. Really, it's the police force itself as a whole that's providing that disclosure. But in this one particular case, the judge was very specific on the wording that he wanted me to draft for the court to approve. The chief of police himself will attend court to explain why his service hasn't done it. They did comply to that one. So there's a little story for you. So the chief of police for an area can apply for one of these orders. Chief Constable of British Transport Police, Transport for London, Transport for Manchester, the Environment Agency, Natural Resource Body for Wales, Secretary of State for Security, Welsh Ministers for Security. They can all apply for one of these orders. And also, without notice, you don't have to be there. They don't have to tell you that they are doing this. And in the case where it's a local authority or the police or a housing provider that is making the application, and where you've engaged in or threatened to engage in conduct that is threatening use of violence or there has been a significant risk of harm to another, then the order can have the effect of excluding you from where you live. Now, again, I don't have so much a problem with that as there's the harm element involved. I expect a court would take a higher threshold for that, but it can have the effect of excluding you from where you live. So in a nutshell, the court simply has to believe on the balance of probabilities that someone has caused or is likely to cause harassment, alarm or distress to any person, which is what they define to mean antisocial behaviour, and then they can make an order without notice, without you being there, which could be indefinite, which if breached is contempt of court. So you could have an unlimited fine or go to prison for 2 years. So without ever having been told about the application for the order, and just because they apply because they believe there's a threat of you committing antisocial behaviour, which could cause somebody distress, they may make an order which make you do and not do things for as long as they say, and if you don't do or not do those things, you'll be in contempt of court with an unlimited fine and potentially go to prison for 2 years. How do you feel about that? Because that's what's winging its way through at the moment with this crime and policing bill, which is here. We are now at the report stage. It's going to its third reading soon. This is sponsored by Yvette Cooper of Labour. Then it will move to the House of Lords, go through all the same processes again. And at the end, we sometimes get parliamentary ping pong. It goes back and forth between the Lords and the Commons because they don't agree with what's in it. And hopefully someone has sense and says, this can't be right because this is quite silly. And I hope to some degree that they see my video and someone thinks, yeah, I don't think the public will be very happy with that. But likewise, something that the public won't be happy with is this one here, because this is from the Employment Rights Bill. In a very similar vein, we have the liability for the protection from harassment, where employers are going to have liability for harassment by third parties. That being where the employer must not permit a third party to harass one of their employees, which could, by way of example, have the effect for pub owners, venue managers, cafe operators, or anyone else, frankly, that has employees, particularly where they face members of the public, customers, and everyone else. For example, the example used is banter in pubs, where people make jokes in a pub. If an employee felt that they've been harassed, and that could be as a result of anything that one of their customers has said, and the employer hasn't taken steps to prevent it, the employer's liable for one of the customers making jokes that the employee doesn't like. So I think all of this is just a little bit ridiculous. But that now is in the House of Lords, having already been through the House of Commons. And again, hopefully we get some kind of common sense and we go back and forth to see that this really is curtailing free speech and just a little bit too far. And there are several others, but I think those two are enough. Let me know what you think about those in the comment section below. Are we genuinely going down this route where we are losing free speech altogether? And even before you've actually done it, if there's just a threat that you might do it, threat that you might be held responsible for someone else's distress, that without notice you'll be ordered potentially to do or not do a thing for as long as they say. Let me know what you think. Please do like the video and subscribe to the channel. This is a way I can bring you genuine commentary on the law as it is. And as always, thank you for watching.